Just who can sue you? It's kind of from the other side. I mean, I know that vendor pre-purchase reports are an issue, and I don't know how many of you do it. If you don't do it, if you do it, and the questions that I usually get around this are, well, a purchaser's come in and has relied on a vendor pre-purchase report, and can the purchaser rely on that? Can they sue the person who did the vendor pre-purchase report? But I'm kind of looking at it from your side. It obviously is relevant to if you're having a crack at a vendor pre-purchase report, but I thought we'd look at it from your end. And so the three things that are most pertinent to this are identifying your client, whether third parties can rely on your report, and how can you limit your liability. So firstly, identifying your client. How do you identify your client? It's very important, because as a contractual matter, we have in law this thing called privity of contract. And under privity of contract, that means that the only people who can rely on breaches, the only people to whom you have obligations, are the other parties to the contract. So identifying who the other party to your contract is very important. Now, the easiest way to do it is obviously to have an express term in the contract that says client, Mr. or Mrs. Bloggs, or Mr. and Mrs. Bloggs, and you as the consultant. You need to give it some thought, though. I mean, if you've been retained through a solicitor, you wouldn't ordinarily be putting the solicitor's name as the client. You might want to put the solicitor's name as the client, but I bet the solicitor won't be happy with that. If you do, however, it suggests that unless it's a problem, because although you've got the solicitor's name there as a client, you might know that the solicitor is really retaining you on behalf of the solicitor's client, which means the solicitor's acting as the agent. So although you might think that you're only on the hook to the solicitor, you're actually on the hook to the solicitor's client, and not the solicitor. So you want to be careful about that, what it says expressly in your contract. But there are other things that might impact on exactly who the other party to your contract is. So, for example, who's paying? Who are you sending your bill to? Are you sending your bill to the solicitor, or are you sending your bill to the client? Because the person who's paying may say, well, hang on, no, I'm the client, not who's written on the contract. So you need to be a bit careful around that. And you need, and I would suggest in your contract, it would be best to have an express term that says, no matter who actually pays my invoice, the client is the person who's named as the client in my contract. Who's giving you instructions? So the solicitor says, okay, I want you to come and do a pre-purchase inspection for this client of mine. But then you get phone calls from the client, and that suggests that the client is actually your client as well, because that's where you're getting instructions from. So is somebody else, and let's assume for a minute that you've got the name of, say the property's in the name, or the purchaser is going to be Mrs. Bloggs, but Mr. Bloggs is running the show, and he's the one who's giving you the instructions. Now, at the end of the day, does that mean you're going to be liable to just Mrs. Bloggs, who's the name on your contract, or to Mr. Bloggs as well? Can Mrs. Bloggs have a crack at you for following Mr. Bloggs' instructions in terms of what you were to look at and what you were to do? So you need to be careful around that as well. And I'd suggest if someone is giving you instructions that isn't the person who's named as the client, that you want to get something in writing from the client saying that you can rely on what that other person tells you, and you can convey your advice to that other person, and that is taken as being received by your client who's named in the contract. And lastly, where are you sending the report? Are you sending the report to the solicitor? Are you sending the report directly to the clients? Are you sending them to someone else? In the same way as I was talking about who's giving you instructions, are you sending the report to the client who's named in your contract, or are you sending it to somebody else? if you are doing that, then that can expand the range of liability. So you need to identify who your client is. You need to make sure that whether that person or somebody else is paying you, that still remains your client. And you need to be very careful about who you're getting instructions from, that your client has authorized those instructions and the receipt of your advice, and that you're sending the report to the place that your client has authorized you in writing to send it. So that's that part of it, identifying your client. The next thing is reliance by third parties. And this is, again, harking back to this vendor pre-purchase report issue. If you're preparing a report for Mr. and Mrs. Bloggs, if they then pass that report on to somebody else, whether they're a vendor or maybe they're a purchaser and they know another person who's interested, they drop out, but they know someone else who's interested, they pass your report on to them. Are you liable to those people? Who what third party other than your client might be able to sue you because they say they've relied on your report and it's wrong? Of course, none of your reports would be wrong, so that aspect isn't an issue, but we all know that insurance claims and defending even unmeritorious claims are expensive, so, and time consuming more than anything else. So reliance by third parties, what you want to be doing, unless you are deliberately and consciously assuming that third parties and assuming that third parties will be relying on your report and you're happy to expand that range of liability, if that's not the idea, then you need to have express terms in the report that says this is only to be relied upon by our client. Preferably identify the client in the report. I know a lot of reports use a bit of shorthand and say it's only to be relied upon by the person who instructed us to give the report, or only to be relied upon by our client. Again, for the reasons that I was discussing in relation to the previous slide, just saying your client might not be specific enough. So I would be putting in my report, this can only be relied upon by my client, and identifying the client. You probably also want to say it can only be, so the other thing is, what's the purpose of the report? Now, the reason that question is relevant is because if you know that your report is not just for your client, but it is to be relied upon by others, it's to be circulated, then you need to be careful about that, because it could be said, well, hang on, if the purpose of the report, and this is particularly in relation to vendor reports, was to be relied upon by others, then you may well be inviting liability to those others, even if you say in your report, well, this is only to be relied on by the person who has contracted, who has ordered it, who's retained me to do it, because they've retained you to do it, but why? So that can become an issue. And how long can someone rely on it? Can it be relied upon in a year's time when things may have happened to the property in between? I'd suggest you want to be limiting the time for which your report can be used as a potential purchaser for the purpose of buying the property. Then, and that's a good segue into how can you limit your liability to, whether it's to the client or to others? Well, again, you go back to express terms in the contract. So you limit your liability in the contract to what? You can limit it, as we discussed earlier, to the particular client, the named client. You can limit it in amount. You can say that my liability will not exceed the cost of the report, or 3 times the cost of the report, or a specific figure. You can try and limit it that way. I mentioned limiting it in time, how long, and that's not just a case of for how long can it be relied upon, but also in terms of when can a claim be notified. So you can put in your terms, I will only be liable provided a claim is notified to me within 3 months, 6 months, 12 months of the date of the report. So those are the kinds of things that you can put in terms of limitation of liability. And I would suggest to you, again, to try and avoid this liability to third parties, that you put that fine print, if you like, in the report itself, because a third party is not going to see your contract. They're only going to see the report. So if you've got it clearly in the report, these limitations of liability, then that makes it difficult for a third party to rely on it as well. And that then leads us into what we call the consumer guarantees. So under the Australian consumer law, if you're providing a service to a consumer, by law, you give certain guarantees as to the proper and workmanlike conduct, fit for purpose, merchantable quality, and things like that. In your case, it's fit for purpose. So you're providing a service that can be reasonably expected to provide the service that is advertised. You can't contract out of these things. But a question arises as to reliance. So those consumer guarantees you can't contract out of. You can't say, I'm not giving any warranty as to the quality of my service. That's there. But particularly, but firstly, that only applies to the person with whom you have contracted. So it's the consumer that's bought your report that's retained you. So again, all these things are connected. Circle back to the beginning. Very important to identify who your client is. Now, you could also be liable under Section 18 of the Australian Consumer Law, which is that provision that says you can't engage in misleading and deceptive conduct or conduct that may tend to mislead or deceive, and which is kind of akin to negligence. But that really comes down to reliance. And so the person who's trying to say, well, I relied on your, and they would say misrepresentation as to the quality of the house or the building, they have to show that they've relied on that. Now, if you've got a term in the report that says no one else can rely on this except my client, they can only rely on it for a certain time, etc., then that makes it difficult for the third party to say or to establish that they have relied on your report. And if it got to court, your lawyer would be cross-examining the consumer and saying, well, you read the report, there it is in black and white. You can't rely, only the person who was the client can rely on this report. So you can't tell the court that you relied on this. It's a matter of credit. It's a matter of what's reasonable. Would the reasonable person have relied on a report that says you can't rely on the report? It's not it's not a perfect solution, but it gives you an argument. It gives you something to negotiate over. And ultimately, if you can't negotiate out of it, then it might be something that actually saves you. And the last thing I'll mention is, and this goes back to your contract, you can put a term in your contract whereby your client gives you an indemnity against claims by third parties. So you're saying to your client, this is for your use only, it's not for anybody else's use. And yes, I have a contractual relationship with you. You've paid me. So yes, I accept liability to you. I don't accept liability to anybody else. And if somebody else comes and sues me, you're giving me an indemnity. I can join you to those proceedings, and any amount for which I'm found liable to that third party, presumably because you've passed the report on, you give me an indemnity and you've got to pay any amount for which I am found liable. That can also be a useful tool in your contract to help you avoid an unexpected liability. So that's a fairly brief overview of the position. Have we got any questions?